and not being watched or disturbed by other people? Or is it a question of right to dignity and right to have boundaries? But how diffuse or rigid the boundaries should be, and who should be defining these boundaries? That is the question. And Cambridge Dictionary describes it as someone's right to keep their personal matters and relationships secret. But what is personal? How personal things can be? Fact is that whenever an individual in society does something, it can impact the society at large. So privacy can be at all levels. It can be between husband, wife, lovers, mother and son, any individual and anybody in the society. So it's a very wide net we are talking about. And human beings are social animals, and purposive socializing is what distinguishes us from the rest of the animal kingdom. So how far can one individual be allowed to stay private? How do we balance individual privacy with responsibility towards the society? And how does the state or the government balance between honoring a person's privacy and ensuring safety of all individuals? These are very moot points. Is it okay for Big Brother to be watching us? Is it okay for IT companies to know all about our habits? Is it okay for social media to lay us exposed to the rest of the world? On the other hand, Mark Zuckerberg would say that it's not how much we would like to know about you, it's about how much people would want to reveal about themselves. So these are conflicting views. Vivek, you have chosen a complex issue, but I must say you've done a great job. And today we have great legal luminaries here to unveil your book and to shed light on the issue of privacy and how we can balance things. It's my proud privilege to welcome Honorable Mr. Justice Sanjay Kishan Kaul, our chief guest for the evening, Honorable Mr. Justice Siddharth Mridul, our guest of honor, along with keynote speaker and eminent jurist, Professor Upendra Bakshi. May I now request our chief guest, Honorable Justice Sanjay Kishan, accompanied by other dignitaries, to please unveil my dear friend Vivek Sood's new book. Gentlemen, I request your indulgence. So Vivek, your book is officially launched and legally launched by the luminaries. So I wish you all the best. And we take it from there. Now, I feel very happy and proud to introduce a great teacher, Professor Upendra Bakshi. Professor Bakshi is a jurist par excellence and a stalwart in the field of legal academics. LLM from prestigious Berkeley, California, USA. He taught in Sydney Law School, Australia, as well as Campus Law Center in Delhi. And he went on to become the Vice Chancellor of Delhi University. Guru Gobind dohu khade kake lagu paye, balihari Guru aapne jin Gobind diyo milay. As a teacher, Professor Bakshi made deep impact on the students' life, and students would often say, Roshni dur talak jayegi magar shart ye hai ki salike se jalao mujhko. And he ignited a wonderful spark in them. When Professor Bakshi was a teacher in Campus Law School, our chief guest, our guest of honor, and the author of the book to be launched today were all students in the same institution. Guru Gud, Chela Shakkar. So Professor Bakshi is beaming to see his students from his institution touching the sky today. He has authored innumerable articles which are quoted all over. May I now request Professor Bakshi to deliver his keynote address on compliance and enforcement of right to privacy, an uphill task. Professor Bakshi, please.
I think you're muted. Yeah. Now I unmuted myself. Yeah. Yeah. Okay. So I was saying, thank you, Dr. Gulati, for kind words. Dr. Mr. Justice Sanjay Kaul, Mr. Justice Middle, the bridegroom of the day, who has written this book, Sri Vivek Sood. The dear friends, very kind of you, Dr. Gulati, to introduce me again to this distinguished people and the distinguished author of the book, and saying such nice words about me. I'm reminded of the Bard of Evan who said, I'm a ewer of the wood and carrier of the water. I'm nothing more than that. And it is important to be together on this joyous occasion. My only contribution to legal education, I look back, I began my lectures in jurisprudence class. Some of you might remember, by saying, we had a guidebook series called Dukhi. Jo padega Dukhi, wo hoega Dukhi. The result, the guidebooks over the years tried to catch up with my teaching in jurisprudence and legal theory, and they improved. So my greatest contribution to legal education in Delhi was to improve the quality of the guidebooks. We wish we had books of this kind, which is also a guide, but not a guidebook. It's a guide to right to privacy, which is absolutely revolutionary. I want to start with a story, but I don't think LiveLaw can present the story. It's about, so I'll share it with this audience. It is attributed, I don't know the source of the story, but I got it on the internet. And it's a caller is saying, is it Pizza Delight? Answer is no, sir, it's a Google Pizza. Caller says, I must have dialed the wrong number, sorry. No, sir, Google bought this pizza chain last year. Then he said, I'd like to order pizza, and he orders a hefty, non-vegetarian, unhealthy pizza. And this is what I want. And the caller, and he offered a vegetarian pizza full of vitamins. And the caller says, no, I detest vegetables. What the hell do you know? Then he said, well, your cholesterol is not very good, sir. How the hell do we know? Well, we cross-reference your whole phone number with your modified with your medical records, and we have the result of a blood test for the last 7 years. Excuse me, sir. You have not taken your medication regularly. According to our database, you purchased only a box of 30 cholesterol tablets once at so-and-so drug network 4 months ago. Caller says, I bought more from another drugstore. That doesn't show in your credit card statement. I paid in cash, says the caller. But did you not withdraw enough cash according to your bank statement, says Google? That doesn't show in your last tax return that you did a scam for which you're liable. What the hell? He says, customer says. And the other man, and the man at the other end says, I'm sorry, sir, we use this information solely the purpose of helping you. And he goes on, and he says, enough, I'm tired. I won't tell you the full story. Enough, I'm tired of this. I want it out. I don't want pizza anymore. And the other side says, I understand, sir, but you must renew a passport. According to database, the passport is expired. It expired 6 weeks ago. And short of going mad, the customer banks the phone. The point of the story is simple. And that's what the book is about. what is called surveillance state and surveillance capitalism by Susanna Zuboff is here to stay. Both the state and the market depend on social media in a big way. They use them and they are used by them. And right to privacy is the work of judges, especially of the Supreme Court, but also of various high courts in India. The book is an extraordinary, lucid book. How did you write such a lucid book on such a difficult subject? I'd like to learn from you. It's a very complex development of constitutionalism in India. It is important because it affirms R2P, right to privacy, in an information era. But it's complex for many reasons. First, it's complex because R2P, a short form, right to privacy, R2P discourse is a highly judicial discourse. R2P is a judicially invented right, and like all such rights, is normally derived from the expanded interpretation of judicial discourse, Article 14, 19, and 21, and even the basic structure. So in derivation, there's several points to origin, which have been traced wonderfully in this book, and chart different futures of the R2P, which also this book explains very well. Secondly, and this is a puzzle, and my lord, Sanjay Kaul is here, and he will be more qualified to speak on this. But he insists, and many of his brothers insist in Potoswami, that R2P is not merely a legal, a constitutional, a fundamental right, but also natural right. However, a dinosaur of sorts. So my mind goes back to 1955 article of Professor Herbert L.A. Hart, H.A. Hart, who had nothing to do with the Indian Constitution development. He was interested in it, and he wouldn't understand it, being an Englishman. But he wrote an essay called "Are There Any Natural Rights?" And he found by way of answer that there were no natural rights, but there was one natural, if there was at all a natural right, there was one natural right, and it was the right of all, equal right of all men to be free. He didn't count R2P, privacy, as a natural right. But we don't have to believe in Professor Hart, but even in Kishan, the Supreme Court did not go so far, and the Kishan presenting as Potoswami perhaps goes, to call it a natural right. The natural right is something that is inherent to human beings. I understand why the court said it. But it's also subject to certain limitations. Natural right is not subject to limitations. It is not conferred by the state or the law. It is conferred by something beyond state and the law, and it can't be taken away. So it cannot be taken away. It affects your dignity, the derivative right of dignity, liberty, and life. It's important. Mr. Sood, this is a great book. You don't get to this jurisprudential thicket and spoil what you're saying. I'm spoiling a lot of your book, reading a book by my own jurisprudential garbage. But it's a wonderful book. And what I most like, well, I think I like everything about it. It's a rare book in that sense. Your emphasis that social media has become an integral part of good life in India is a very important idea. And your idea that we can ill afford at the same time to wholly surrender to market or the state. Preserve the idea of liberty. The discussion of Justice Chandrachud in Aadhaar case is fantastically important, and you're right to devote almost a whole chapter to it. And you ask people, and rightly, you call it underexplored, underaddressed literature on Portugal. And you note somewhere, of course, that he spoke about money bill and federalism invalidated law, but that's not your concern. But I think that should be our concern too, because federalism is an important part of a matrix of limitations on rights, or limitation on power to amend the right, more important. And I think that Justice Chandrachud's dissent in Aadhaar needs to be looked at from this point of view. No matter what the majority said, the dissent is prophetic because it preserves the basic structure of Indian constitutionalism, which inter alia lies in federalism. I like very much, Vivek, your condemnation of what you call telegraph mindset, which is the attitude of state control and censorship and regimes of unbridled discretionary powers. I can go on. I like the book so much. I like, for example, the idea that the various progressive decisions on sexual minority, on adultery, on many other fundamental rights declared as fundamental rights by the court are a part of like sexually explicit material, sexual privacy, and I want to quote you, are all offspring from the womb of privacy. I like that. I like setting these decisions in a context of autonomy and how to be. Although, mind you, some may resist this heteronormative titling. Speak about the womb and children, offspring. It is essentially heteronormative. And you're talking of sexual liberation at the same time. But in context, it is very fine, he said. Now, I don't have much time. I already run out of my time. So I will not give you the history of an article that Indian Law Institute published before we entered the internet era in 1982, which was titled, "Who Bothers About the Supreme Court of India?" And this article was uniformly not read by the lordships who have something to do with running of the Indian Law Institute, presided over by the Chief Justice of India, and senior justices are associated with it, by my fellow academics, by lawyers, like Vivek, I don't think you've read this, many other people. And essentially my idea was that one must analyze the impact of judicial decisions. And we don't do it in India. I kept on saying this, but nobody listened. Somebody has called me Upendra Bakshi, the professor of pathos and minor jurisprudence. I like that, or Sarkar. I've written a long article on it. So not being taken seriously is not a problem, but it is a problem for R2P. And therefore we must take the impact of privacy to account. Now we all know Section 67A and what happened of the Information Technology Act. It was invalidated by my Lord Justice Chalmeshwar and Justice Rohinton Nariman on the ground of being overbroad. 5 years later, in between, you discovered that police still behaved as if the section was not struck down. 5 years later, a full writ petition has been filed before the Supreme Court on the ground that 1,000 FIRs have been filed under a law that is invalidated on the ground of privacy. Now, I must say the Home Ministry acted very promptly and wrote to all the duties and the states saying they must enforce the right to privacy immediately. They must enforce the invalidation and sensitize law enforcement agencies. There can be a greater joke than that in India. But that's what they say. Ultimately, it's a federal matter. So federalism is deeply relevant to the spread of free information technology. Think about this enforcement by the state or against the state. Think about enforcement against multinationals and surveillance capitalists. For example, right to be forgotten. For example, content regulation, which you deal with in great detail. For example, Pegasus. Talking about Pegasus, I must thank you, Vivek, for touching on a very sensitive matter. But as a jurist, I must say you did not touch it not on the basis of a political conviction. And you in fact say so. You analyzed it in legal terms, juristic terms. This is how lawyers and judges ought to proceed, in my not so humble opinion. And therefore, it's a very, very great thing that you've done it. And you said that governments will come and go, but threats to right to privacy remain. And how are they best to be addressed in the future is a very important problem. Now, I've taken a lot of your time. I'll end with 2 big ideas. I want a second edition of this book. And I want in the second edition of this book, at least 2 or 3 chapters on first the international pedigree of R2P. Both international, Universal Declaration of Human Rights onwards, major international convention on covenant on civil and political rights, and a large number of regional instruments, treaties, a large number of soft law instruments speak about R2P. And I think the Indians should have the benefit of knowing about it. Secondly, I think the role of NGOs is very important to bring the matter before. And you consider this in some detail in your book. That's very worthwhile. But I think we need to go to other post-colonial societies. Take, for example, Uganda. That's for example. It has 4 major NGOs for unwanted witness, the NGO. It has got a PI, Privacy International organization. It has got a CIPESA, a Center on Communication Technology, and so on. Therefore, I think it's important also to look at the role of Human Rights Commission in promoting R2P. And the report currently issued under its auspices by Irene Khan, formerly of Amnesty International, on what she calls institutionalized digital disorder. How state use digitalism for the purpose of development and governance, but also how they are clients of multinationals who control their surveillance capital, and how they report to them in case of military digitalization. We talk a lot about cyber terrorism and R2P, and of course, a very real problem. One should deal with it. But we have to think about how they interfere with even elections in democracies. So disordered what she calls the spate of misinformation. He makes a distinction between misinformation and disinformation. And disinformation is intentional, misinformation is unintentional. And the havoc that it could play with democratic ordering, civil society ordering, is a established fact. And currently the US is looking at a Facebook proceedings, might have all seen on CNN, how it affects the life of children and teenagers, how it's content. So how would state regulate this without losing sight of its good side by controlling its ugly and bad side? That's a very difficult matter. And I think Vivek would be, you won't shun hard work, I know, but he will be well advised, requested to do a second edition which looks at a little bit of post-colonial scenario. The constitution, the current constitutional case in the point, which is specific guarantee of privacy. There are many colonial, post-colonial constitutions after the globalization, in the 80s, from Uganda to East Timor. How have they handled or thought to handle their constitutional law in matter of privacy, fundamental rights? And some have enshrined privacy as a fundamental right very early on, 80s, early 90s, and so on. And we ought to look at that. But I think I've said enough by way of general remark. Congratulations for a fine book. It will go a long way for both, if I may speak, for all law persons, and certainly for the bar and for the students of law, but also for the lordships of the Supreme Court and High Court, how to interpret the versatile creature that unleashed on all of us for the good of India. Thank you.
Thank you, Professor Bakshi. Indeed, right to privacy is a natural right, no doubt about that. And listening to you, one suddenly gets an urge to become your student all over again. Thank you very much.
Thank you.
And now I feel very happy to introduce our guest of honor today, Justice Mr. Siddharth Mridul, alumnus of prestigious Hindu College and Campus Law Center, New Delhi. He had a roaring practice as a lawyer and was elevated as a judge to Delhi High Court in 2008. Before that, he did tremendous work as a standing counsel for Union of India, member and secretary of Bar Council of Delhi, member of several committees of High Court for rehabilitation of children after abolition of child labor. Justice Mridul has a very pleasant demeanor and gives lawyers a very patient hearing, the reason why all the lawyers love to appear in his court. Justice Mridul has given many landmark judgments, for example, granting bail to JNU students who protested against the Citizen Amendment Act and National Register of Citizens. The bench observed that in his anxiety to suppress dissent and morbid fear that matters may get out of hand, the state had blurred the lines between constitutionally granted right to protest and terrorist activity. A strong statement, but good for the society. Congratulations, sir. A humanitarian at heart, he has always advocated attention to human rights, especially to the victims of crime. In 2020, he directed the government of Delhi to ensure that riot victims were given accommodation, food, and medical aid. May I now request Honorable Justice Mridul to please come and share his thoughts with us. Thank you, Justice Mridul.
Thank you, Dr. Yash Gulati. It's a pleasure to be here today, particularly in the august company that I find myself in. My esteemed senior colleague, Justice Sanjay Kishan Kaul, has always been a beacon for all of us who have followed him as judges of the Delhi High Court. And I would be, even if I said that he's been a role model for most judges at the Delhi High Court, it would be an understatement. I must also I must also say that I've always held him in the highest esteem and admired not just his approach to judicial work, but his approach, his attitude to life, and his being at the vanguard of social justice and social change. Uh, it gives me great pleasure to be here uh, at the online book release of Vivek's book with Padma Shri Dr. Upendra Bakshi, the distinguished scholar of this country and one of the most influential teachers in the world. And I'm certain that Professor Dr. Bakshi doesn't remember much about much about me from the Campus Law Center, but he has his writings, his teachings have always been uh, he's always been a he's always cleared the path that we need to follow. Um, I also welcome all the youngsters and lawyers and law students who would have uplinked to the present release, because this, in Shashi Tharoor's words, is a timely work that asks the questions that need to be asked in a world where privacy is ever more threatened. I must congratulate Vivek on uh, on his prodigious uh, effort in coming up with a book on one of the most historic judgments to be delivered to be ever delivered by the Supreme Court. I think this is a judgment that in some ways is at the vanguard of changes that we will see in the development of constitutional law and individual rights and liberties in the years to come. And it will mark a watershed, just like Keshavanand Bharti and ADM Jabalpur did in in uh, in the eras gone by. Um, there was a lot that I wish to say, but essentially, I would once again congratulate Vivek and wish for him that he continues to take up challenging issues and take the bull by the horns, so to speak, and continue to argue for the people, because fundamental rights are something where both thinkers like Dr. Bakshi, authors like Vivek, and judges like my Lord Mr. Justice Sanjay Kishan Kaul and myself, we need to constantly push the envelope, particularly when it comes to the right to privacy. There is only one suggestion that I have for Vivek, and that is that although he has covered almost every aspect of the right to privacy with regard to both state and non-state actors, I believe the right to privacy also needs to be protected. The right to privacy of an individual also needs to be protected from society in general. Right? The inviolable right of an individual to be let alone uh, should extend not just to state and non-state actors or multinational social media companies like Zomato, and but it must also extend to the society around you. So I believe there is something that you need to. In fact, it's important for us to mainstream segments and sections of people of the population who are on the fringes of society, transgenders, LGBTQs. It's very important for us to mainstream them, and it's very important, as you rightly advocated, that their rights and their privacy must be accorded the highest precedence. And I believe that is an area where Vivek, possibly more research and more thought-provoking questions must be asked. Um, well, in conclusion, I will end with this couplet from Allama Iqbal. He said, "सितारों से आगे जहां और भी है, अभी इसके इम्तिहान और भी है." I wish you all the very best. It's been a pleasure being here. Thank you and good evening.
Thank you, Justice Mridul. I'm very happy to see that you're also interested in Shero Shairi, which is my passion. And similar on these lines is कि जुस्तजू हो तो सफर कहाँ खत्म होता है, वरना हर मोड़ पे मंजिल का गुमा होता है. So I'm sure Vivek will have to write more books. This is only one step towards where he has to go. So now today I have to now invite the bridegroom of the party, my friend Vivek Sood, an alumnus of Mayo College, Ajmer, Campus Law Center, Delhi University. Vivek is running a flourishing law practice. Sorry, my video went off. Vivek is running a flourishing law practice and was designated as a senior counsel by Delhi High Court in 2015. Apart from law practice, Vivek has lectured extensively at various forums and is a prolific writer. The Information Technology Act came into force in 2000 in India, and out came Vivek's first book on cyber law within a year, which is still selling on Amazon after 21 years. That speaks volume about the kind of work he does. He further wrote a book in 2010 on cybercrime and electronic evidence. I was fortunate to be involved in the launch of that book as well. Vivek coined the term fundamental right to internet in his book, The Fundamental Right to Internet in 2011. And it was a good thing to note that this term was used by Honorable Supreme Court in 2019 in J&K Internet shutdown case. Only a few months ago, Vivek came out with another book, Emergence of Commercial Justice, Insolvency and Arbitration. And today, we saw the unveiling of his latest book, Right to Privacy, Arguing for the People. So Vivek, I invite you to say a few words, and few means few. Vivek.
Thank you. Thank you, Yash. First and foremost, I am deeply grateful to my Lord, Honorable Justice Sanjay Kishan Kaul, for gracing this occasion as chief guest and for releasing my book. Amongst the numerous qualities of Justice Kaul, there is one that I must highlight this evening. Honorable Justice Kaul has the perfect judicial demeanor. When he starts the court in the morning at 10:30 and finishes at 4:30, my Lord Justice Kaul is as calm and pleasant as ever. Every lawyer in his court gets a very patient hearing. And by being patient and soft, Justice Kaul's eye of the fish is justice and equity. Justice is done in Justice Kaul's court in a very serene judicial ambience. And I joined the bar in 1992. So, we were infants when Justice Kaul adorned the bench. So we have learned from his demeanor, his pleasant demeanor, and he does justice in every matter, and he is able to dispose of so many matters in a day. And above all, his demeanor is exceptional. I am deeply grateful to my Lord Justice Mridul, the guest of honor. Justice Mridul's court is the liveliest court in Delhi High Court. While anecdotes and light humor is on, the process of arriving at a judicious decision is always going on in Justice Mridul's mind. Justice Mridul's court is a court where lawyers come out happy even after their cases are dismissed. I am deeply grateful to Professor Bakshi for delivering the keynote address this evening. He was my guru. He taught us criminology and jurisprudence between 1989 and 1992. I am fortunate to have him on the dais, after 30 years of having been a student. He's a stalwart of legal academics, not only in India, but across the world. I'm grateful to my good friend, Dr. Yash Gulati. He's Padam Shri and a noted orthopedic surgeon. He fixes the bones and knees of who's who of the country. And his last patient was none other than Mr. J.P. Nadda, the BJP president. So therefore, my good friend, he's helping the BJP government walk and run. I'm grateful to Mr. Ajay Veer Singh Jain, the president of Indian Advocate Forum, who has sponsored the evening for the release of my book. And he's running this Indian Advocate Forum, which is a pan-India organization, which will take up the causes of the legal community. I'm grateful to Thomson Reuters for publishing my book. I'm grateful to LiveLaw for hosting this program this evening. I'm deeply grateful to Mr. Shashi Tharoor for penning the foreword of this book, to Mr. Mukul Rohtagi, to Mr. Rajdeep Sardesai, and Mr. Manish Tiwari for penning blurbs and endorsing the book. I'm grateful to my family and friends for their motivation and good wishes. And last but not the least, I'm grateful to the audience who has made this evening special. Insofar as the book is concerned, it will be judged on its own merits by the readers. But I must say a few words about the book. I have consciously kept it crisp. I could have written about 300, 350 pages, but I've consciously kept it within 160 pages so that it's readable. It can be read over a weekend. I have followed the journalistic format, which means that it is devoid of technical legal jargon. So I've kept it very readable for the people at large. Amongst the myriad issues that I have dealt with in this book, I have addressed the three major controversies surrounding the right to privacy in the year 2021. First, we had the intermediary rules of 2021, which grant wide powers to the law enforcement agencies to violate the privacy or to violate the privacy of the citizens for investigative purposes. I have tested sub-rule 2 of the intermediary rules of 2021 on the anvil of the constitutional validity. Secondly, I have dealt with the toolkit controversy that erupted between the BJP and the Congress party. And we would recall that it was alleged by the BJP that Congress party had created this toolkit to defame the government of India. The Congress party shot back saying that the toolkit was a fabrication. So I have tested the toolkit controversy and I have suggested and made out a case for reforms as to who enforces and who adjudicates the disputes with respect to the right of privacy between political parties and major political forces in the country. I have also dealt with the Pegasus controversy in the light of the law of evidence. I have addressed the question as to whether there is legally admissible evidence to say that the government of India is involved in spying and snooping using their privacy, using this Pegasus software. Insofar as my vision of the enforcement of right to privacy in future is concerned, it depends upon the will of the people. How far will the people want their privacy to be protected? If people will insist on their privacy to be protected, the IT world, the telecom players will create products which will protect the privacy of the people. So it will ultimately, in my view, the enforcement lies in the hands of the people. So I will not keep the audience, away from my Lord Justice Kaul. We are all eager to hear Honorable Justice Kaul. I hand over the baton to my dear friend, Dr. Yash Gulati, to invite Justice Kaul to give his insights on the subject. Thank you.
Thank you. Thank you, Vivek. My next job is really a very difficult one. It's like सूरज को दीपक दिखाने वाली बात है कि I have to say introductory words about Justice Sanjay Kishan Kaul. And it's my privilege to say these few lines about him, who is our chief guest today. A Stephenian and alumnus of Campus Law Center, he became a High Court judge at a very young age of 43. And this was preceded by a highly successful law practice in High Court and Supreme Court. His eminence and astute legal mind impressed one and all and helped him to climb the steep steps to the coveted position of Chief Justice, High Court of Punjab in 2014 and judge in Supreme Court of India in 2017. It is said that a good judge conceives quickly and judges with patience. And that's Justice Kaul. Justice Kaul delivered many landmark judgments in his illustrious career, and many of the passages have become now locus classicus. For example, in M.F. Hussain case, he said, quote, "Pluralism is the soul of democracy. There should be freedom of thought we hate. Freedom of speech has no meaning if there is no freedom after speech. The reality of democracy is to be measured by extent of freedom and accommodation it extends," unquote. So, and this is quoted many places, and we cannot forget the landmark judgments related to allowing women to appear in National Defense Academy exams, avoiding delays in judicial proceedings by unending arguments by lawyers. Today, Vivek was brief, but sometimes they are not, and decision regarding obstruction of public ways by protesters, and I can go on and on and on. I'm sure Justice Kaul would enjoy reading Vivek's book, Right to Privacy, Arguing for People, as he himself was part of 9-judge bench in Puttaswamy case, in which right to privacy was declared a fundamental right. Justice Kaul said, George Orwell created a fictional state in 1984. Today, it can be a reality. The technological development today can enable not only the state, but also the big corporations and private entities to be the big brother. These are complex things, and we are very fortunate, and I feel humbled to get this opportunity to invite Justice Sanjay Kishan Kaul to please come and address us and give his wisdom. Justice Kaul, please.
Very good evening to all of you. Professor Upendra Bakshi, Justice Siddharth Nudal, Dr. Yash Gulati, Sanjay Sanjay, and the bridegroom, as it is said, Mr. Vivek Sood. I belong to an era of the law faculty when very eminent professors adorned that position. Mr. Tripathi, Dr. Upendra Bakshi, Mr. Madhav Menon, Professor Latika Sarkar, and many more. And we had the benefit of guidance from all these people during our tenure. But most importantly, they emphasize the significance of academic writings and critiques of legal judgments, to which I am a party. I think in most developed countries, the advancement of law arises from what are the critiques written of different judgments by different authors, which itself becomes an input for purposes of writing further judgments and evolution of law. And I think we are going through that phase where more and more writing will come, as with the current scenario, more people who are academically inclined are going towards teaching and education. Dr. Yash Gulati has been comparing the program. It's an unusual situation. And there is something in common with doctors and lawyers. I also happen to be one of the lawyers for almost 2 decades. Most people think that it's best that they don't have to approach us. That's a common factor, I think, in this audience, that unless necessity arises, there's no need to get to a lawyer or a doctor. On the issue of writing a brief book, let me say I do believe that the book should be brief, the judgment should be brief, and the argument should be brief. All three. the invasion of right of privacy or the right of privacy, in a sense, has a long history so far as there is a concern. And I'll say why. The day you give your consent to become a judge of any court is the day the invasion of right to privacy for that person starts. And you come to know many things about yourself and your family, which you may be unaware of. So this is something which has been consistent when you talk about media, we talk about aspects in public domain. We are in the beginning itself confronted before we take up a job of being put in the public domain without knowing about what we are supposed to know. Now, coming to the issue of right to privacy in the sense of Swami's judgment and the development of law. Reams have been written on what constitutes the true meaning of privacy. It's a concept that has nuanced and layered. It's simplistic and fundamental. A good starting point is the succinct definition given by Warren and Brandes in their article, The Right of Privacy, where they attributed privacy to simply be the right to be left alone. This role of privacy as an instrument of social change takes on true meaning only when we mold itself to accommodate and provide for new challenges that are fast changing the world present. It's almost 4 years ago that 9 of us came up with the unusual unanimous judgment, maybe with certain different opinions on different aspects and nuances of privacy, and in one voice upheld the right of privacy as a fundamental right protected under Article 21 of the Constitution of India. Puttaswamy not only interpreted for the people of India the right inherent in their right to life, it also gave a fresh lease and was a testament to the dynamism, vitality, and the effectual nature of the Constitution of India, of something Professor Upendra Bakshi is an expert. And keeping in mind, complementing the changing strides of the Indian society and culture and the challenge of technology which arose. This also demonstrated the Constitution's ability to accommodate the multidimensional nature of the law. The challenge before us in 2017 emanated from the emergent concern vis-à-vis the Aadhaar scheme, a biometric ID system which was intended to be implemented through India. Chapter 2 of the book also analyzes the same, along with the dissent judgment by my brother and class fellow, Justice Sanjay. Dissent is always, in a sense, a brooding for the future, because it often paves the way for a thought process for what may be the change of law. The particulars of what was thrown before us pertain to and were the byproducts of technological advancements and indicator of the changing times and changing concerns, which have been many and have moved with tremendous speed. The journey from the decision in MP Sharma in 1954, one of the first judgments of the Supreme Court relating to the right of privacy, to K.S. Puttaswamy, which overruled its finding that there is no fundamental right to privacy, may be one of evolution and coming of age of this country, a different era, as citizens exercise their entitlement and the institution evolved to move ahead with the times. In this context, I am reminded of the words of the American jurist Paul Fruin, who said, "The court should never be influenced by the weather of the day, but inevitably they will be influenced by the climate of the era. To remain objective in the face of overpowering public discourse, while being cognizant of changes in public through its onerous task, but also the sacrosanct duty of the courts as custodians of law. It has often been realized that some thoughts and opinions are considered untenable at a particular point of time. But it is only several years later that the significance of such opinion dawned upon us. One such dissenting opinion was penned down by Justice Subbarao in the case of Kharak Singh. Justice Rao chose to dissent as he opined that the police regulations were unconstitutional in its entirety, as it infringed Article 19(1)(d) as well as Article 21 of the Constitution. He had, in his missionary words, held, indeed, nothing is more deleterious to a man's physical happiness and health than a calculated interference with his privacy. The implications of legal protection of privacy are manifold. Therefore, it follows of a constitutional right to privacy goes even beyond. It is perhaps best understood by what one might say has been the exalted application of the case of Nashte Singh Johar of Union of India while decriminalizing homosexuality. The Supreme Court noted that with the findings of Pittaswamy case, the challenge to the virus of 377 had become stronger than ever, ultimately holding that it had breached both fundamental rights to privacy as well as human dignity. While Pittaswamy's judgment forms the backdrop of the privacy law infrastructure, what one faces today are new and ever-evolving threats in the form of surveillance, aggregation of data, commercial collection of data, and more broadly, data used to restrict constitutional and other rights. The technological utopianism which stuck as in the turn of 21st century to finding the move fast and break things approach today needs visiting in the light of greater scope of technology enabled intrusion into private life. As the internet rapidly permeates the country, it becomes increasingly important to address the intersection between civil rights and threats posed by technological advances in the digital sphere. The promise of mathematical and computational models being capable of identifying key insights from data, which can in turn be used in private and public decision making, is what can make data a dangerous and destructive asset if not collected, processed, stored, and shared in an appropriate manner and within a sound legal framework. Beyond the legal frameworks, it is in view of these eventualities that even in everyday life, our presence on the World Wide Web today may arguably amount to taking the metaphorical fruit of the poisonous tree. Chapter 3 of the book delves into the aspect of relationship between intermediaries, e-commerce platforms, and the right to privacy. As the internet has reached nooks and crannies of the world, this has resulted in data flowing back and forth to unimaginable speeds, resulting in digital footprints being left behind after every communication and transaction. These footprints contain pieces of information pertaining to a person's interest, which while individually may seem innocuous, but in aggregation may provide details about a person's religious belief, sexual orientation, personal habits, and political affiliations. The very kind of information which is either shared voluntarily or confined on in confidence and has the potential to be exploited from motivated ends. Let me say I've sometimes found that even while a mobile phone is lying on the table and some discussion is happening in the sitting room of the house, some kind of advertisements start playing out or access, which has in some way a connection with what is being discussed. I'm not a technical expert, but I'm certainly a worried man to know to what extent can your private room discussions form a basis of whether it's advertising or going beyond advertising and invasion into your privacy. On the flip side of things, we must realize that the right to privacy, even when fundamental, is not absolute. The lack of absoluteness is in the sense the reasonable restriction can be placed on it, provided these restrictions are fair, just, and reasonable. The fear of unreasonable restrictions may be appeased by placing reliance on the proportionality principle, which is all about the means being well suited to the ends. An application of the principle reveals that this right may be interfered with only if a four-pronged approach is followed. There should exist a law that justifies the same. The same should be in pursuance to a legitimate state aim in such a protection, national security, or in public interest. The extent of interference should be proportionate to the need for the same. And lastly, there should be procedural safeguards to protect against the possibility of abuse of such interference. With this conceptual foundation, the enactment of domestic legal framework protecting the modern person's right to privacy is much awaited. This is more so in the light of the fact that countries across the globe are introducing their own laws to safeguard the rights of their citizens and regulate the handling and use of data by both the state as well as non-state actors. In this regard, it may be useful to gain insight as to the origin of legislation pertaining to data protection. One of the first data protection policies was framed in the United States in 1973 by way of a report of the US Department of Health, Education and Welfare. The principle laid down in this report became the basis for data protection regimes in other countries, including the Asian Pacific Economic Cooperation, APEC, private framework, and the European Union's General Data Protection Regulation. India is also moving towards creating its own data protection regime. A committee headed by Justice Krishna was set up in 2017 and examined the issue of data protection. It submitted a report along with the draft bill to the government, a modified version of which crystallized into the Personal Data Protection Bill 2019, which was tabled before the Parliament and is currently pending before the Joint Parliamentary Committee for detailed examination. Accordingly, we can be hopeful about the fact that India may soon have advanced and well-implemented data protection regimes, which will ensure protection of personal data of individuals and will curtail the misuse of this by state and non-state actors alike. Chapter 5 of the book debates this bill in detail and provides us valuable insights. The book very insightfully also delves into domains where there is need to usher the right to privacy in more functional manner. There are domains which are yet to see an evolution that comes with passage of time amongst other factors. I'm fairly confident that as we evolve as a society, the public, the legislature, and the judiciary together will find fair and equitable ways of ensuring that the import of these rights reach their domains as well. While drawing things to a close, I congratulate Mr. Vivek Sood for conceptualizing a book which is fascinating and easy to follow. Thank you and good night.
Thank you, Justice Kaul. It was an honor listening to you. Indian Advocate Forum is a knowledge-sharing platform for professionals engaged in different streams of legal profession, and it has presence in almost all the cities in India. And today we have none other than the president of this forum, Mr. Ajay Veer Singh Jain, Advocate Supreme Court, to propose a vote of thanks. Mr. Ajay Veer Singh Jain, please. It looks he is not able to join us, Vivek. So why don't you do the honors?
No. Audio.
Am I audible now?
Yes.
Good evening. Today's event is a very special kind of and a unique kind of event where we have the campus, we have the court, and the link between the two, that is Vivek Sood. Vivek writes books and Vivek practices in the court. And we have one of the best two judges over here. And as Vivek has already said, whatever the outcome of the case, when we come out of the court, we are happy, despite the outcome. And that's the great credit we give to Professor Bakshi, who has produced lawyers who are also jurists and judges who are thinkers. Speaking about Professor Upen Bakshi, not much is left, but my experience about Justice Sanjay Kishan Kaul, when we were lawyers in the High Court and I looked at Justice Sanjay Kishan Kaul, then senior advocate, I suddenly told somebody why we don't have judges like him. And then we had his elevation. And we desired much more. And similar kind of thing happened when we were interacting with Justice now Sr.Ad and then senior advocate, and he also became judge. What is the common denominator of today's panel is Faculty of Law. I have to not only thank, but feel grateful. I'm indebted to all of you for being here. And the greatest thing about today's event is that this is being seen and heard across the length and width of this country. Indian Advocate Forum has made it possible that a lawyer from even a smallest of the taluka is connected with other lawyers across the country. Thank you very much for being here, and thank you very much for making this event. And Vivek, not the least, when Professor Bakshi says it's a great book, it is a great book. Thank you, sir.
Thank you very much. I think with this, we can come to the end of the program, and thank you everybody for sparing time. And we wish Vivek the very best. And I'm sure you'll bring out many more books, and we'll all be there to cheer you up. Thank you. Good night.